what was the foundation for their legal defense? Was it that it just wasn't fair, that the system isn't fair to the company? I'd like to hear sort of the legal argument. I don't think I've heard that. If you can expand on it.
Yeah, so what you just said, what Todd had said, and what I mentioned earlier. They pushed very hard through the evidence of what they put before the court about what they're having to spend. The real defense, if you will, for their actions was the future liability that they face. And because of the future liability and the uncertainty, when you take those numbers and you extrapolate them using the numbers they used, that, hey, judge, look at all this liability we face. They had slides and presentations, no evidence, but argument that it's going to be in the trillions of dollars and that there will be cases for the next 60 years. So they used all the sum of their fears, if you will, is what they felt should drive the bankruptcy. Our position was, no, bankruptcy is not a menu choice, for one of the richest companies in the world to opt out of the jury system. They wanted the benefits of bankruptcy and then claimed literally in the same breath that look at the trillions of dollars of future claims we face. But then they, to this day and in the court, denied that there's any merit to the claims. There's no science. They don't agree with any of the science. They still deny their products ever contained asbestos. So it's a catch-22. If the claims are worthless and the science is worthless, then how can you say that, having as much as $60 billion in available funds through a funding agreement, that you're in financial distress?
Right.
And Maureen, it all comes down, in my mind, to smoke and mirrors. They want to say, well, we're going to face 100,000 cases in the future, and we're going to put this big number that has been awarded in a trial on every one of those cases, right? That's what they want to say. If they take the number, the true number, and even just put what we in the business would understand to be a really high settlement value, but a reasonably high settlement value on each case, you'd be at 25 or 30 billion dollars at the worst, and they've got $61 billion set aside for this. So there's no way they're in financial distress whenever maybe the liability adds up to half of what they got available to them for this case. Set aside the fact that a $450 billion company should not be able to file bankruptcy on a liability that may be 20 or 30 billion dollars.
Right.
It's ridiculous.
It's incomprehensible. So basically they're saying we're going to set aside $2 billion to resolve all the outstanding claims. Is that right? And then we just want to move on, basically. Right.
So there's a lot of detail to that analysis, but they began by putting aside $2 billion. They have a funding agreement that gets you up to the $61 billion is what they have. But their own counsel, their own internal in-house counsel has said he doesn't even think their liability is $2 billion. So if it's not even $2 billion and you've got $61 billion, you're not in financial distress.
Right. But that's the number that they want to use if they had to end all the current and future baby powder suits.
That's the initial number they've put on.
Yeah.